Hello everyone, welcome to IAS Academy. In this video, we will be talking about an issue between Legislature and the Judiciary. In today's Hindu newspaper, that is 22nd April 2023 newspaper, we have an article in the editorial page. So in this context, we'll be analyzing the issues between the Legislature and the Judiciary. At the end of the video, we'll also be talking about something called as Collegium system, and I'll also be discussing a very important mains question called as what are the critiques of the Collegium system. So in order to get more such enriching content, please subscribe to IAS Academy as of now. Okay, so let's start with the issue. So if we look at the context, why are we even talking about the Legislature versus Judiciary? For people who are starting the polity as of now, I'll just make the things very clear. Legislature means the institution which makes laws. For example, Lok Sabha, Rajya Sabha in the central government. Similarly, we have state assemblies, okay, and the state council, legislative assembly and the legislative councils in the federal level. So these comes under legislature. When we talk about judiciary, it is the entire system of justice delivery system. Supreme Court, High Court, district courts, okay, tribunals also are a part of judiciary. So here, India, which we are talking about the separation of powers between the legislature, executive and the judiciary, but here where the separation of powers are an integral part of the constitution, which is also a part of the basic structure. So here we are talking about legislature versus judiciary. Okay, this can also be termed as legislative superiority versus parliamentary supremacy. Okay, so this what is happening between legislature and the judiciary. See, this is the article that we have in the Hindu newspaper today, that is a veto by silence. Okay, this refers to the tussle that's happening between legislature and judiciary. So let's analyze what is the issue, what's happening between the parliament and the Supreme Court. See what Supreme Court did. There's an institution in the Supreme Court called as Collegium system, which we will be talking about in a few minutes. As of now, just understand that the Supreme Court recommended a person called Justice Muralidhar as the Chief Justice of Madras High Court. Okay, which means Justice Muralidhar was recommended by the Supreme Court to the government in order to appoint Justice Muralidhar as the Chief Justice of Madras High Court. Okay, this is the procedure. Usually, the Supreme Court would recommend the elevation of judges to the High Court and also to the Supreme Court and also the transfer of judges. Okay, so the Supreme Court would recommend this and the government will approve this. When the government approves this or the president approves this, then the particular order is said to have been executed. So on the same lines, even now, the Supreme Court recommended the name of Justice S. Muralidhar as a Chief Justice of Madras High Court. Recommended to whom? The President. Okay, and the President will act accordance with the Council of Ministers, which will be headed by the Prime Minister. So what did the government do now? The Union government, after receiving the recommendation by the Supreme Court, kept quiet for 8 months. For completely 8 months, the government did not act on this particular recommendation. So now what the Supreme Court did? Supreme Court took back its recommendation and recommended Ganganapurwala Justice, which is Justice S.V. Ganganapurwala, as the next Chief Justice of the Madras High Court. Okay, so the Supreme Court took back the recommendation where it said Justice S. Muralidhar would be appointed as the Chief Justice, and now it said Justice Ganganapurwala would be recommended by the Supreme Court as the Chief Justice of Madras High Court. Okay, so there is no explanation given by the government or the President for the delay of these 8 months. This is what the article talks about, veto by silence, where the government did not act on the recommendation of the Supreme Court. It vetoed it by remaining silent. And now what is an issue? Recent instances of government using inaction as a mean to stall appointments. Veto by silence. The government action of remaining silent and vetoing the recommendation by the Supreme Court or the judiciary is been increasing over the years. The concerns are rising about the impact of the independence of the Supreme Court. See here, Supreme Court, the judges of the Supreme Court have the power to appoint the other judges. This is the only institution where the judges appoint the other judges and there is no interference with respect to any executive for that matter. Okay, so with respect to the independence of the Supreme Court in appointing its own judges, such silence or such veto by the government is creating alarms. Okay, this is the concern pertaining to the independence of judiciary, which is also a basic structure of the constitution. The executive's circumvention of the judicial primacy by refusing to give effect to the Collegium recommendation is a challenge which the judiciary and the parliament both have to look for. See, we are talking a lot about the Collegium system. What is it about? How does it work? What does it do? Okay, this is a time where we will understand what is Collegium system in appointing the Supreme Court judges. See, let's keep this discussion very much limited to the Indian reference. Okay, see, we have a lot of Collegium systems around the world, but the Collegium system that we have in the Supreme Court, which is very much specific to the elevation of judges to the Supreme Court and the Chief Justice of the any High Court, is what is the matter of discussion as of now. You can see here, Collegium system is a group of 4 senior most judges of the Supreme Court, including the Chief Justice, which means this will include 1 Chief Justice of India and also 3 other Supreme Court judges, 4 judges of the Supreme Court who are most senior, and these people give recommendation based on consensus to the government for the appointment and also the transfer. Okay, so this group is called as Collegium system of Supreme Court. How did it come about? Okay, how did the Collegium system evolve? For the first time, in the year 3rd judge's case, in the year 1998, that is in the 3rd judge's case, before this we also have the 1st judge's case and the 2nd judge's case. The Collegium system is a result of the 3rd judge's case in the year 1988, where it talks about the Collegium system. Not only this, there are multiple judicial interventions from 1998 till 2023. Over a period of this time, 25 years down the line, the Supreme Court has come up with a lot of other judgments where the Supreme Court has talked about Collegium system, and one such judgment was the Supreme Court Advocates on Record Association case in the year 2015. Okay, so here it said the recommendations by the Collegium should be unanimously made. Okay, it should be unanimously made that the government's role is limited to providing inputs and not veto power. See, according to this particular case, judicial procurement, the judicial announcement that happened in the year 2015, the Supreme Court says that the government should not enjoy veto power over the recommendations of the Supreme Court. So now what is the composition? I've already told you the composition. The Collegium system comprises of the 4 senior most judges of the Supreme Court. Okay, and these judges are merit based. There is no other qualification to be a part of the Supreme Court Collegium other than seniority and merit. Okay, now coming to the mains discussion of what are the critiques of this particular Collegium system. If you look at the first one, the lack of transparency. Clear? See, the judiciary here, the Collegium system to be specific, will nominate a person. For example, it nominated Justice Muralidhara as the next Chief Justice of the Madras High Court. But nowhere on the website, nowhere by the Information Bureau, okay, nowhere by PIB, nowhere by any of the government document, the Collegium will say that these are the parameters that we have considered to elevate this person as the Chief Justice of Madras High Court. Okay, and this is not a part of the RTI also, because there is a complete lack of transparency and there is opaqueness in the elevation of judges. Okay, lack of diversity. Okay, so here we just talked about the 4 senior most Supreme Court judges who are elected or who are in Collegium because of their merit and experience. Lack of diversity. Concentration of power. The concentration of power here in the sense, the 4 judges who are a part of Collegium are the sole responsibility in order to elevate judges or transfer judges from one high court to the other high court. Okay, concentration of power. Lack of checks and balances. As I've told you, this is not a part of the RTI also. Okay, so there are no mechanisms for any kinds of checks and the balances with respect to the recommendations by the Collegium. Judicial overreach. See, separation of power is a very much integral part of the basic structure of the Constitution, where it talks about the law-making process is the function of legislature, executing the law is the function of executive, and if there is any dispute arising out of this law and also its execution, then it is the work of judiciary to look into it and to solve it. Okay, but here what's happening, the work that has to be done by the executive, that is appointment of the judges, is being carried out by the judges themselves. So this is the judicial overreach. So these are the very, very important critiques or the limitations or the concerns or challenges of the Collegium system. So that's all for the day. If you have liked the video, subscribe to the Legacy IAS YouTube channel. Have a nice day. Thank you.